Uh, can we switch off this light? This one? Yeah. Glare आ काफी से. First of all, thank you, ma'am, for having me here, and it's a privilege to be amongst the students to explain the intricacies of the competition law. I have been working with the Competition Commission of India since 2011, and I have been fortunate to work both on the merger side, where the companies approach us seeking approval for their mergers and acquisition transactions, as well as on the antitrust side, where we look into the anti-competitive agreements, as well as the abuse of dominant position. During my tenure with the CCI, I have also worked with the Committee on Digital Competition Law, which formulated a report and drafted a digital competition bill also, which has been submitted to the government, and it is under consideration of the government. I have been very fortunate to work on some important digital market cases in the commission also. So I'll try to share my experience during this presentation. So this is just a brief history and the present status of our competition law. You must be knowing that the predecessor of the Competition Act 2002 was the Monopolies and Restrictive Trade Practices Act 1969. But in 1991, the government liberalized the Indian economy, and with that, a wave of reforms started. The government constituted a Raghavan committee to examine the MRTP Act, whether it suits the needs of the reformed or a liberalized economy. And the Raghavan committee recommended a new competition law, which is at par with the modern competition law jurisprudence across the world. They studied multiple jurisdictions, and they proposed a new law. So this particular law was passed in 2002 by Parliament, but due to some jurisdictional issues, the law could only be enforced in 2009. In 2007, the law was amended by virtue of Brahmadat judgment of the Supreme Court, and then in 2009 onwards, the provisions of the law were notified. The anti-competitive agreements and abuse of dominant position provisions were notified in 2009, and the merger and acquisition provisions, which we called combinations under the Competition Act, were notified in 2011. Recently, the competition law was amended by Amendment Act of 2023. So I'll be discussing the important amendments which have been introduced in the law during the presentation. This is just a brief overview of or the distinction that competition law has with the MRTP Act. The Competition Act is based on a liberalized regime, whereas the MRTP Act was based on a command and control regime. Under the MRTP Act, the dominant position itself was considered to be was seen as a very negative. But this is not the position under the competition law. Only when an entity abuses its dominant position, it is considered to be violative of the law. The MRTP Act did not have provisions relating to regulation of combinations, but the Competition Act had a detailed procedure of examining and approving mergers and acquisitions, which meets a particular threshold. Then the Competition Act do have provisions for advocacy, where we go across the country to various stakeholders and explain the nuances, the intricacies of the law. This was not the position under the MRTP Act. There was no provision to impose penalty under the MRTP Act, and only cease and desist orders could be issued. But under the Competition Act, Commission has vast powers to impose penalties. And during last few years, Commission has been very active in digital markets and other markets, and imposed penalties on contravening entities, which included Google and Meta WhatsApp. Then under the MRTP Act, there was no provision where the government bodies or other statutory authorities, they can come to the Commission and seek guidance as to whether a particular policy of the government is pro-competition or anti-competitive. But under the Competition Act 2002, these bodies can come to the commission and they can seek guidance whether a particular policy reform by government or a new policy of the government will increase competition in the market or it will suppress competition in the market. So these are the basic objectives of the Competition Act. It is to prevent practices having adverse effect on competition, to promote and sustain competition in markets, to protect the interest of consumers. And here I would like to mention that the definition of consumers is very wide under competition law. It not only covers the end consumers, but also the intermediate consumers. So apart from B2C transactions, we can also look into B2B transactions. So the intermediate consumers are also covered by the competition law. And the last objective of the Competition Act is to ensure freedom of trade. Just to give a brief background, the composition of the commission as per Section 8, it says that it shall consist of a chairperson and not less than 2 and not more than 6 other members to be appointed by the central government. Currently, we have 4 members including chairperson, and the decisions are taken by a majority of the quorum. The quorum is as per section proviso to section 22 subsection 3 is 3 members. So if the 3 members are not present in a particular meeting, the commission cannot take any decisions. And as per section 10, the commission or the members of the commission, they hold office for a period of 5 years or till the age of 65 years, whichever is earlier. We also have office of Director General, which is the investigative wing of the commission. I'll come to the process also, how the cases are received in the commission and what are the role of the commission as well as the office of the DG. So DG is the investigative wing of the commission. Earlier, as per the Competition Act 2002, the appointment of the DG was by the central government, but the 2023 Amendment Act changed the procedure, and the appointment of DG is to be by the commission, but with the prior approval of the central government. So the process has been given to the commission, but before appointing the DG, the commission has to take approval from the Ministry of Corporate Affairs. The role of DG is assisting the commission in conducting inquiry into contravention of any provisions of this act. Section 3 and Section 4 provisions, whenever commission makes a prima facie finding that there is a problem, then the matter is referred to the Director General for investigation, which submits a report to the commission, and that report is then shared to the parties, and on the basis of responses received from the parties, then the commission conducts an oral hearing and reaches a final conclusion into the matter. These are the basic functions of the commission. Section 3, 4, 5 and 6, these are the enforcement functions of the commission, which are ex post or we can say adjudicatory in nature. These are Section 3, which is prohibition of anti-competitive agreements, and Section 4, prohibition of abuse of dominant position. These are ex post because once the conduct happens in the market, then the commission comes into the picture. They examine whether the conduct is violative of the provisions of the law. So that's why it is ex post. It is after the conduct. The second enforcement function of the commission is ex ante, that is Section 5 and 6, assessment of combinations. This is called ex ante because the law imposes a liability or an obligation on the merging parties that they has to take a prior approval of the commission before they can complete their transaction. But not all transactions are required to be reported to the commission seeking approval. Only those transactions which meet a certain threshold, which is defined in terms of either the value of assets or value of turnover, and recently introduced a deal value threshold. So only those transactions which reaches a particular threshold which has been given in the Act as well as amended through notifications, only those transactions are required to be reported to the commission seeking approval of the commission. Then under Section 49(1) and Section 21, we have advisory functions where the government or the government bodies, they can come to the commission seeking guidance. Lastly, section 49.3, it is advocacy function, where we go and explain to the stakeholders about the provisions of the law. So this is a passive enforcement. We believe that advocacy, when the stakeholders know about the law, there are less chances of violation of the law. So this is a kind of passive enforcement where we go to multiple stakeholders, be it corporates, be it industry bodies, be it other associations. We go to them, we explain the provisions of the law, what is permitted under law and what is not permitted under law, so that they are well aware of their responsibilities in their business decision making. Competition law is applicable on enterprises. Now, what are enterprises? Section 2H defines enterprise as which includes a person or department of government. So there is competitive neutrality under the competition law. Any government body, any private body which is engaged in any economic activity. So there is no distinction between a government body or government itself and a private body. If they are engaged in any economic activity, they are covered by the provisions of the competition law. Now, what is that economic activity? That economic activity may relate to the production, storage, supply, distribution, acquisition or control of articles or goods or provisions of services, or in the business of acquiring, holding, underwriting or dealing with shares, debentures or other securities. So these are an example of what are economic activities which are covered under the Competition Act. But Section 2H also excludes certain sovereign functions of the government which are not covered under the competition law. So they specifically 3 functions are mentioned, which are atomic energy, currency, atomic energy, currency, defense and space. So government departments dealing with these 4 aspects, they are not covered by the provisions of the competition law. So coming to Section 3, this is the first enforcement function of the Commission. Section 3 deals with anti-competitive agreements. So Section 3.3 deals with horizontal agreements and Section 3.4 deals with vertical agreements. I'll just explain it with an example, with a diagram. A horizontal agreement is an agreement which is between players which are situated at the same level in a value chain. For example, competitors, because they are operating at the same level. So it's an any agreement between competitors in a market. It's called an horizontal agreement. They can be competitors. They deal in substitute goods, and any agreement which is between players which are at different value chain, different levels in a value chain. For example, a manufacturer and a distributor or a retailer. So that is an agreement, vertical agreement between players which are situated at different levels in a value chain. Now coming back to the Section 3, the horizontal agreement as per the Act they are presumed to be legal. So there is a presumption created in the law that whenever competitors agree or get into an agreement in relation to these 4 things, then there is a presumption that this particular kind of agreement is illegal under the law, under Section 3.3, and the burden of proof shifts onto the parties to show that the concerned agreement do not result into any appreciable adverse effect on competition. So Commission is not required to prove any impact on the market, and the burden shifts onto the parties. The kind of agreement that are covered under horizontal agreements, these are price fixing, where competitors come together and they fix prices. Instead of market forces deciding the price, where they compete effectively with each other, they come together and they fix prices of goods and services. So that kind of agreement is presumed to be illegal. Then market allocation. This market allocation could be geographic allocation, where different competitors or supplier, they divide geographies among themselves. That supplier A will deal in North India, supplier B will deal with South India. So these kind of geographical allocation is also considered to be illegal under the law. Then it could be consumer allocation also. For example, a particular size of consumer will be dealt by a particular supplier, or they decide the consumers amongst themselves So these kind of market allocations are also considered to be illegal under the law, and there is presumptive liability on the parties concerned. Or if an agreement limits or controls production or supply of any goods and services. For example, if two competitors come together and they decide that they are going to reduce the production of a particular good in the market so that scarcity generates and the price can go up. So these kind of agreements, and again, are covered under horizontal agreements. And the last one is very important, bid rigging and collusive tendering, because public procurement is one such area where most of the procurement by government happens through tendering process. The purpose of inviting bids is a fair discovery of price. When there is sufficient competition in the market, bidding process will result into a fair discovery or discovery of market price in the of a particular goods or services. But when the competitors or suppliers, they collude with them with each other, they prevent that fair discovery of the price. So any kind of bid rigging or collusive tendering is also prohibited under law. And again, presumption is that it is illegal, and the burden is on the parties to prove that any agreement between them, these competitors or suppliers, has not resulted into any appreciable adverse effect on competition. So the test of competition under competition law, whether it is section 4, section 3, section 4 or section 6, it is appreciable adverse effect on competition. It is not only adverse effect, because the statute specifically says appreciable adverse. So there is a distinction that has been created between adverse effect on competition, because any agreement between competitors is likely to result in an adverse effect on competition. But the law says that it has to be appreciable adverse effect. Then there are parameters given in respect of when the effect on the competition will be considered as appreciable. This is about the horizontal agreements. Now coming to the vertical agreements. So unlike horizontal agreements, which are presumed to be illegal under the law, vertical agreements are examined by the commission on the basis of rule of reason. So commission, while examining the conduct of the parties concerned, they examine whether the conduct has resulted into any appreciable adverse effect on competition. So there are multiple parameters. For example, if the parties are very strong, if you can say that if Amazon enters into some kind of arrangement with its suppliers on the platform, so that kind of arrangement is likely to result into some sort of market distortion. So that kind of arrangement, when the upstream player is pretty large in the particular market, they are not dominant, because if they are dominant, then it goes into section 4. But they are short of dominance, because in e-commerce market there are two large players in in India, Amazon and Flipkart, and section 4 does not envisage any position which says collective dominance. So section 4 do not have any requirement of or any provision which says that collective dominance can also be examined under the law. So if a particular market there are no dominant players, but it's a duopoly, then each and every player in that duopoly, both the players, they can have, their conduct can have anti-competitive effects on the market. So those kind of markets are considered under section 3.4 or the vertical agreements. And commission, while examining the conduct, they see whether how much market has been distorted in that particular by virtue of that particular conduct. So there are 5 types of arrangements or agreement that have been prescribed under vertical agreements or section 3.4. These are tie-in arrangements. Tie-in arrangements are basically when when a buyer reaches out to a seller that I want to purchase product A from you, but the seller says you have to purchase product B also from me. So that kind of arrangement, tie-in arrangements, are considered as tie-in arrangements, and that can be examined. If I can give you an example, for example, if you go to purchase a vehicle, and the manufacturer or the dealer says that you have to purchase insurance from us only. So that kind of arrangement between purchase of vehicle is product A, and that purchasing of insurance from same dealer or the distributor or the manufacturer. So that kind of arrangement can be examined under this particular clause. We have seen cases where such complaints have come to us, stating that the dealers or the companies are forcing us to take insurance from the same dealer. But we found that the dealers incentivize taking insurance from them, but there is no obligation to take that. And the consumers are free to take insurance from other agents also. So there is no obligation, there is no tie-in arrangement. It is not that product A is not available with product B. So tie-in arrangement, product A is not available without product B. So both the products have to be purchased together. Then it can be examined under tie-in arrangements. Then we have exclusive dealing agreement. Under exclusive dealing agreement, the seller prohibits the buyer from procuring products of any other supplier in the market. So these kind of arrangements qualify as exclusive dealing agreements. If I take an example, for example, Amazon, they enter into an agreement with a seller on the platform that you take only my logistics services. For example, the fulfilled by Amazon service. If they say that you have to take my logistics services to sell your products on the platform, so that kind of arrangement can be considered to be an exclusive dealing agreement, and it can be examined. Then we have exclusive distribution agreement, where the seller imposes a restriction on the distributor in respect to a geographical territory within which the distributor can sell the products. So an exclusive distributionship is granted to a particular person, and no other dealer is permitted to sell the products in that allotted geography. So that kind of agreements can be examined under exclusive distribution agreement. Then we have refusal to deal, where a player, they refuse to deal with a particular or a class of persons. Again, for example, if Amazon, they refuses to list a supplier on the platform, unless and until the platform has a justification why they are refusing to list a particular supplier, they can be examined under refusal to deal, and it can constitute a refusal to deal. For example, all these platforms, they have a criteria which every supplier or the seller on the platform has to meet. So if the supplier is not meeting that criteria, then Amazon is justified in refusing the supplier. But if the supplier is completing or complying with that criteria, and still Amazon is not allowing the particular supplier to list all the products on the platform, then it can be considered as a refusal to deal. Then lastly, we have resale price maintenance. Resale price maintenance is basically when the seller imposes a condition on its buyers that you have to resell the product at a particular price only, that you will not give discount below this particular price. We have seen cases in automobile industry relating to resale price maintenance or RPM. We imposed fine of 200 crores on Maruti because what we saw that Maruti was restricting its dealers from giving a discount beyond a particular range. Maruti has a whole machinery in place. The Maruti people were going to the dealers as disguised as customers to check what kind of discounts the dealers are giving. Penalties were being imposed on the dealers who were giving more discounts to the dealers, to the consumers. So Commission, when examined the entire matter, they found that Maruti has violated this particular clause and has engaged into resale price maintenance, and a fine of penalty of 200 crores were imposed on Maruti. One important thing is Section 3.4 is not applicable to an agreement with an end user. So Section 3.4 only relates to B2B transactions. B2C transactions are not covered under Section 3.4. This is a change that has been introduced by 2023 Amendment Act. Earlier to that, we received multiple cases where an end user came to the Commission alleging that Section 3.4 has been violated. But the government, through this amendment, has mandated that such kind of complaints cannot be examined under 3.4, they can be examined either under section 4 if it qualifies there, but not under 3.4. And the intent of section 3.4 is only to look into the B2B transactions which has sufficient impact on the market and they create market distortion. This I have already covered. One important thing about section 3, that is the anti-competitive agreement, the definition of agreement is not formal as given under the Indian Contract Act. Agreement under Competition Act includes any arrangement or understanding or action in concert, whether or not such arrangement, understanding or action is formal or in writing. So a wink between two competitors when they are meeting in a bid process, when they are meeting the bidder, the tendering authority, because generally tendering authority calls for meeting with the various bidders. A wink between two suppliers can constitute an understanding. So there is no requirement of having a formal or a binding contract or a written contract between these suppliers to constitute an agreement under the Competition Act. Then it is not required whether or not such arrangement or understanding or action is intended to be enforceable to be by legal proceedings. One important thing that we have also seen in our cases, and the Commission has clarified, that even if you have not implemented the agreement, though you agreed with the other supplier that you will quote this particular price in a particular bid, but while submitting the bid, you submitted a different price as per your own internal calculations. But Commission found that you have vitiated the process by engaging into an agreement. Once you entered into such kind of arrangement with the other competitors, you have violated the law. An excuse that I have not implemented such kind of arrangement is not a sufficient excuse which can give you freedom from the violation of section 3. Because section 3 uses a language, an agreement which causes or likely to cause. So that's why the Commission took a position that even if the agreement has not been enforced or they have not been implemented, but that section 3 stands violated. So coming back to bid rigging, section 3.3d defines bid rigging as an agreement between enterprises or persons engaged in identical or similar production or trading of goods. That therefore the bid rigging agreement can only be between competitors or suppliers in the same tender, which has the effect of eliminating or reducing competition for bids or adversely affecting or manipulating the process for bidding. So this is the definition that has been given under the section 3.3d, and each and every word of this particular provision is challenged before us when we examine a particular matter. So we have to satisfy all the parameters of this particular definition before we come to a conclusion, yes, this was a case of bid rigging and the parties can be penalized under the law. These are the forms of bid rigging. There could be cover bidding, where because generally what happens in tendering processes, the authorities, they require minimum 3 bids to be received. We have seen cases where there are suppliers who just submit a bid to complete that number 3 numbers, but they are not serious bidders. So this is called cover bidding. Then there are bid rotations where the suppliers take turns. For example, because there is a number of tenders which come, and supplier take turns who will win the bid. This is called bid rotation. Subcontracting, where once the supplier gets the contract, they subcontract the bid to the other competitors in the same bid. Then market allocation that we have already examined, geographical or user or the customer allocation. Then bid coordination, where the competitors, the suppliers, they get into in contact with each other. They decide what kind of arrangement, what kind of conditions will be put in the bid, whether they will enter into the negotiations after opening of bids with the tendering authority. Then bid suppression, where they suppresses or they do not allow other competitors in the market who want to submit a bid. So these kind of arrangements can be considered as bid rigging. This is a change that has been introduced by 2023 amendment, which is a hub and spoke cartel. You remember that under section 3.3, horizontal agreements are covered, where an agreement is entered into between players at the same level in the value chain. Whereas section 3.4 covers an agreement which is between players who are at different levels in a value chain. We were looking into, or we received multiple cases where this structure was not there, but the player at upstream was also involved in facilitating a coordination between downstream players. For example, there are multiple distributors of a particular product. The manufacturer of the product was facilitating a coordination between the downstream suppliers. So we took a position that section 3.1 is broad enough to consider such kind of conducts or agreements. But when the Competition Law Review Committee submitted its report in 2019, they suggested that a specific provision or a formal provision has to be inserted in the law to cover such kind of agreements where the manufacturer operates as a hub and they facilitate or they allow exchange of commercially sensitive information between various distributors which are said to be spokes. So the manufacturer, they operate as hub, and various distributors, suppliers, they are considered as spokes in the market. In hub and spoke cartel also, there is a presumption that such kind of arrangement results into an anti-competitive effect on the market, and the burden of proof is on the parties concerned, the hub as well as the spokes, to establish that there is no AAEC in the market. The hub and spoke cartel, we have seen that in multiple jurisdictions, hub and spoke cartel can also be looked with reference to the platforms. For example, if Amazon or Flipkart, they allow coordination between different sellers on the platform, then such kind of arrangements can also be examined as hub and spoke cartel, because the ultimate effect of such arrangement is anti-competitive in nature, and they distort competition in the platform ecosystem itself. So the platforms can also be considered as a hub and spoke cartel in appropriate cases. Then section 46 of the Act, they have some leniency provisions. Leniency is a word that has been used globally in other jurisdictions, but in our law, the word uses lesser penalty. So we do not use the leniency word in our law. The word uses lesser penalty, where a particular member of the cartel, they can reach out to the commission. They can make disclosures to the commission that we were part of this particular cartel, and we are giving you all information, all the documents, email exchanges, other references, or the communications received or circulated in the cartel members, which establish a case of section 3.3. Then that particular cartel member who has approached the commission, they can be given a rebate or reduction in the penalty. So the reduction in the penalty is that the first applicant which reaches out to the commission, they can be given up to 100%. It is not 100%, this is up to 100% of reduction in the penalty. The second applicant is for same cartel, they can be given up to 50% reduction in the penalty amount. And the third and subsequent applicants for the same cartel, they can be given up to 30% reduction in the penalty amount. But there are certain conditions to be met by each of these applicants before the commission can grant a lesser penalty to them. These conditions are that applicant must cease to further participate in the cartel activity, but in certain cases commission can allow them to participate continue participation in the activities of the cartel, so that the other cartel members are not sensitized, or they're not made aware of that cartel has been busted, or the commission is examining that particular cartel. Or the purpose could be so that they can keep collecting more evidences from these cartel members. They must provide vital disclosure. They must provide names of individuals who have been involved in cartels on its own behalf and for whom lesser penalty is sought. They must cooperate fully, continuously, and expeditiously throughout the proceedings, and they should not conceal, destroy, manipulate, or remove relevant documents. We have seen cases where cartel members have reached out to the commission, but during the process they have themselves destroyed certain vital evidences of the cartel activity. So in that case, commission can reduce the percentage of reduction that can be given as the lesser penalty applicant. Then 2023 amendment introduced two significant changes in lesser penalty framework. First is the introduction of leniency plus. Leniency plus is a system where a cartel member who is already under investigation and is a lesser penalty applicant in cartel A, they come to the commission and they disclose existence of another cartel, cartel B. So this is called the leniency plus. Such a disclosure by the cartel member, it allows the commission to form a prima facie view about a possible cartel. Then commission, while deciding the amount of reduction for cartel A, they can allow them an additional reduction of by 30%. For example, there is a second applicant who has got 50%, but when they disclose another cartel, cartel B, apart from this 50%, they can be given additional 30% discount or reduction in the penalty amount. So their total reduction that they receive from the commission is 80%. This is without prejudice the amount of the reduction that they will receive for cartel B. So apart from reduction that they will receive in cartel B, they have got additional reduction in of discount, additional reduction of penalty for cartel A. Another important change that was introduced by Amendment Act was the withdrawal of lesser penalty application. Earlier there was no provision for withdrawal of an lesser penalty application. For example, if as a cartel member I reached out to the commission that I was part of a cartel, there was no provision where I could withdraw such kind of application from the commission. Now the Amendment Act had enabled such kind of withdrawal, and the regulation however require that the withdrawal is allowed, but all evidences that has been given by them in its application, that can be used by the commission as well as the Director General during its investigation process. So that evidence can be used by the commission, but they are not allowed to withdraw their application. This is about Section 3. Now Section 4. Section 4 deals with the abuse of dominance. Section 4 says that no enterprise should abuse its dominant position. As I was explaining, dominant position per se is not a problem under the law. When a dominant enterprise abuses its position, now what is abuse? That I'll explain in the next slide. First is what is dominance. Section 4 defines that a dominant enterprise is its ability to behave independently of the market forces. They are not worried about what happens or how their competitors will react in the market, because they are so large in their sphere of operation that they are not bothered about how the other competitors in the market will react in response to a particular conduct. Or they have a strength of an enterprise to affect its competitors or consumer in its favor. So this is a qualitative definition that has been given by the law. There is no benchmark. For example, if we say 60%, 70% market share, and we can assume a particular entity to be dominant, this is not the case. And it all depends on different factors of the case, how the market is structured. For example, if there are 3 or 4 players in the market, and one player has 50% and other have 30, 20, 10. So that kind of market structure do not suggest that this 50% market share player is in a position to behave independently of the market forces, because there are other significant players in the market with 30%, 20% market share. So this kind of structure do not allow them to operate independently of the market forces. But same structure, if an entity has 50% and there are 10 other players with 5% market share, then we can consider that yes, this 50% position gives them sufficient ability to act independently, and these 10 other players in the market, they are very small and they will not be able to counter the conduct of the dominant player. Then we can consider it to be ability to operate independently of the market forces. So this is a very qualitative determination, and there are multiple factors which have been prescribed under section 19, which determines when the commission will find a particular entity to be dominant. Coming to the abuse, there could be two types of abuses in theory. One is the exploitative abuse, and second is the exclusionary abuse. I'll explain that. Exploitative abuse happens of the user. For example, if I am a dominant player and I impose certain conditions on my users, then it can be considered to be an exploitative abuse, which is an exploitation of my consumers. But there can be other cases of abuse which are exclusionary in nature, which results into exclusion of other competitors from the market. So exploitation is focused on the users or consumers of the platform or the dominant player, and exclusion is focused on the competitors of the dominant player. These are the 5 instances of abuses which have been mentioned under section 4. These are imposing unfair or discriminatory price or condition. So there could be 4 types of abuses in this particular section itself. It could be an unfair price, it could be an unfair condition, it could be a discriminatory price or a discriminatory condition. So there could be 4 different permutation and combination of this particular clause, 42A under the Competition Act. I'll give an example of unfair condition. In 2022, Commission imposed penalty of 1,300 crores on Google. Google, while licensing its Android operating system to the smartphone manufacturer, they were imposing a condition that you have to install all my applications on the home screen of the device. So all Android devices, they were mandated to come with Google Play, Google Search, and a folder which has other Google services. So this commission considered this kind of imposition is unfair in nature, because smartphone manufacturer, they should have ability or freedom to decide what kind of applications to be installed on the device, what placement has to be given, whether they want to install Microsoft Bing on the home screen. So the freedom has to be exercised by the OEM, the smartphone manufacturer, and not by Google. So the commission considered this kind of arrangement as unfair condition on part of Google. If we talk about discriminatory condition, we have seen one case where Google charges 30% fees to the app developers who are selling content to the users. So the rivals of YouTube, they were made to pay 30% commission to Google for every 100 rupee sale to the user. But YouTube was not asked to pay this 30% to Google, because these are two separate products. So this kind of discriminatory treatment, it puts YouTube in a cost advantage where they can price their premium services at a discount as compared to the other rival players. So this kind of arrangements can be examined as discriminatory pricing under the competition law. Then we have provisions relating to limiting or restricting production of goods or services or market or scientific development. So if a dominant player, they decide to stop the production of a particular product in which they are dominant, so as to create scarcity in the market, or they reduce supply in a particular geographical region without any objective justification. So this kind of arrangement can be considered as limiting or restricting production of services or production of goods. Or they decide to not develop or to introduce scientifically advanced or technologically advanced features in the particular product. We have seen cases where certain car manufacturers, they decided that they will not introduce much green energy, green emission technology in their vehicles. So these kind of arrangements can be examined as limiting scientific technology or scientific development of the market. Then we have denial of market access, where the dominant player can reduce or they do not allow its downstream users to come into the market. So, or its competitors also. So denial can happen to its users, denial can happen to the consumer, to competitors also. And it is also not necessary that denial has to be in the same market where the entity concerned is dominant. The denial can happen into a related market also. Recently, Commission decided a case where the Commission imposed a penalty of around 200 crores on Meta and WhatsApp in relation to their privacy policy. Apart from Commission finding that WhatsApp did not give any option to its user whether they want to opt for the data sharing with WhatsApp. If you recall, I don't know how many of you recall, in January 2021, WhatsApp users started receiving a particular update that from 8th of February 2021, either they have to accept mandatory sharing of their data with Facebook companies or they can delete their account. So this kind of an imposition by WhatsApp, which is a dominant player in the market, because everyone uses WhatsApp these days. So this kind of imposition where WhatsApp required users to either accept my condition or you can delete your account from WhatsApp. You can get out of the WhatsApp ecosystem. So this kind of arrangement was seen as imposition of unfair condition under 4.2a. Commission also examined this conduct as giving a data advantage to Facebook, because more than 60 crore Indian uses WhatsApp. And in one go, the data of 60 crore Indian was provided to Meta for advertising purposes. So this kind of data, when given to Meta, they can have multiple, or they can have significant advantages in offering targeted advertisement, which is not available to its rivals in advertisement space. So Commission found that this kind of arrangement, when the data is shared by WhatsApp to Meta for advertisement purposes, it results into denial of market access for the rivals of Meta in the advertisement space. Because this data advantage, the rivals are not in a position to secure same level of data access of the Indian users because of the sheer number of the volume of the users in the Indian economy which uses WhatsApp. So this kind of conduct was examined or concluded as denial of market access by Meta of its rivals from the advertisement market. Then the fourth conduct is conclusion of contract subject to supplementary obligations. This is imposing certain conditions. When you buy product A from me, you have to take product B or product C also from me. Or you say that you will not deal with my rivals. Or there can be n number of conditions which can be imposed by a dominant player in respect of product A, in respect of which he is dominant. So such kind of supplementary obligations can be examined and they can be discussed under section 4. Then the last is leveraging, that is use of position in one relevant market to enter into or protect other relevant markets. This is leveraging. In Google case itself, we found that the purpose of Google asking the smartphone OEMs to install Google search on the home screen is that because Google search operates on the basis of a self-learning algorithm. The more the number of users use Google search, its algorithm improves itself. So that's why the Microsoft and other rivals in the market, they are not able to reach a critical mass where their algorithm is rich enough so they can improve their services. Google, by imposing these kind of conditions, they ensured that 95% of the devices in the country, because nowadays Google search is more used on the handheld devices, mobile devices, and less on the desktops. So Google, by this conduct, ensured that users continue to use my services and my algorithm keeps improving at the cost of my rivals. So Google used its position in the Android ecosystem to protect its market in the Google search, the search market. So this kind of arrangement was also seen as a leveraging, and commission imposed fine in that particular case. So this was about section 3 and 4. The statutory scheme for investigation or inquiry is that under section 19 we can receive complaints or information from any individual or any company. It can be formal information, or we can receive a reference from a government authority or a statutory authority, or we can take up a case on suo motu basis also. Once such information is received under section 19, then commission forms a prima facie view whether a particular conduct or the allegations are prima facie true and they violate competition law. The commission directs the DG to investigate the matter and submit a report. After receipt of the investigation report by the DG, commission forwards the report to the parties concerned. They invite written objections as well as oral hearing is granted. And after considering all the material, commission reaches a final conclusion. Either it can close the matter under section 26(6), or it can impose penalty under section 27, giving a finding of violation of the law. Section 19, who can file an information? It can be any person. It can include an individual, HUF, firm, company, local authority, anyone, consumer or their association, trade association. A reference can be received from central government, state government, statutory authority, or commission can take up the matter suo motu basis. The WhatsApp matter was picked up by the commission on suo motu basis when the commission noticed on 5th or 6th January 2021, multiple news media reports were there. The commission took up that particular matter and directed the DG to investigate the issue. After its investigation, these are the broad powers of the commission. This is under section 27 or section 28 of the Act. Under section 27, commission can pass a cease and desist order where it can direct the parties concerned to continue the conduct which has been found to be violative of the law. They can impose penalty, which can be up to 10% of the average turnover for last 3 preceding financial year. And in case of cartels, penalty up to 3 times of the profit or 10% of the turnover. Then the Amendment Act 2023, it has changed the benchmark, and now the commission can go up to 10% of the global turnover while determining the amount of penalty that can be imposed. Then commission can declare that agreements which have AAEC, they are void and they cannot be enforced. Commission can also order modification of the agreements, and in AOD cases, commission can also order division of enterprises under section 28, but this is section 28 has not been used so far in our 15 years of working. Not used. So apart from the companies, the section 27 talks about the companies, the entities who have violated the law. Section 48 is about the individual liability, where the person in charge and responsible to the company for its conduct, they can also be made held responsible for their conduct. And section 48(1) and section 48(2), it talks about the liability of the concerned individuals when they are responsible for the conduct of the companies, or who were actually involved in the anti-competitive agreement. So section 48 talks about the individual liability. Section 33 is the ability of the commission to grant interim relief till the conclusion of an inquiry, till the commission reaches its conclusion. Considering the peculiarities of the case, commission can grant interim relief, and it can temporarily restrain any party from carrying any act which seems to be anti-competitive in nature. The criteria for granting interim relief, the Supreme Court in sale judgment has clarified the three-leg test, which is an existence of a prima facie case, balance of convenience in favor of the party against which interim relief is sought, and irreparable damage to an entity if interim relief is not granted. So it's a three-leg test which has been propounded by Supreme Court in sale judgment. So this is the brief about the nature of proceeding before the commission. These are inquisitorial proceedings, not adversarial. So we are not here to solve the dispute between two parties at least. We are only looking at market distortion, and when we impose remedies, they are in rem, they are not in personam. So when we impose remedies, it operates market-wide. It is not that if we have found a problem in a particular conduct between two parties, then the party can only change its conduct with respect to other party. No, the conduct has to be with respect to everyone operating in the market. Standard of proof is preponderance of probabilities, being a civil law. The DG has search and seizure powers. As I was explaining, the law is competitive neutral. It applies to both public and private enterprises. And commission's role cuts across all jurisdictions, all markets, sectors. If TRAI looks only after telecom, the commission's role is not restricted to any particular sector. We cuts across all sectors. We can examine any particular sector in the economy. So the regulation of combination is section 5 and 6, which is the ex ante enforcement function of the commission. So the relevant provisions of the Act were effective from 1st June 2011, and regulations were notified post consultation with the stakeholder. As I was explaining, not all merger and acquisition transactions are required to be reported to the commission. Only those merger and acquisitions which meets a particular threshold given in terms of value of assets or value of turnover. And the 2023 Amendment Act has introduced a deal value threshold. For example, the size of the transaction. If it's beyond a particular threshold, then these transactions are qualified as combination, and they are required to report to the commission seeking a prior approval. Till the commission approves the transaction, the parties cannot close their transaction. It is suspensory in nature. They cannot complete the transaction. If they complete the transaction, there are gun jumping provisions where they can be penalized for closing the transaction without commission's approval. But in the interest of keeping it, in the interest of the ease of doing business, the government has fixed the period. Commission can take maximum 150 days while examining the transaction. It's not an open-ended process. So 150 days has been given to the commission, within which commission has to make its decision whether they are approving the transaction, whether they have looked into the transaction, and whether they want to make certain changes in the transaction to address any anti-competitive effect on the market. After this 150 days, there is a deemed approval process. If commission do not approve or take any action within 150 days, the transaction is deemed approved. In case of combination, commission can either approve the transaction if we do not find any problem with the transaction, or commission can approve the transaction with certain modifications where we ask the parties to change the transaction, or they can sell a particular segment of the business where we find problems. We have seen cases in pharmaceuticals, cement, agrochemicals, where we have asked the parties to divest a particular part of the business before the transaction can be approved, because we found problems with a particular part, not the whole transaction. Commission can also reject a transaction if there is no suitable remedy in a particular transaction. But again, till date, we have not rejected any transaction, and there are around 20-25 transactions which have been approved with modification, where we ask the parties to change the nature of the transaction. Then there is a penalty for gun jumping. If the party is concerned, they close the transaction before commission's approval, penalty can be imposed. Commission can seek information if a particular combination is not notified to the commission. Then again, there is a separate penal provision for that also. Then the advocacy functions of the commission. The commission is mandated to take suitable measures to promote competition advocacy, because it's a new law. When 2011 it was enforced, 2009 it was a new law, and to appreciate or to tell all the stakeholders what are the contours of the law, we were asked to go and explain to all the stakeholders what is prohibited, what is allowed under the law. And with changing economic conditions, the implementation or the enforcement also changes because it's an economic law. So with the changing economic conditions, the enforcement nature of the law also changes. A conduct which could have been found problem in 2011, in 2025 it may not be a problem. So with changing times, the implementation or the interpretation of the law also changes, and that's why we continue to do advocacy functions under our mandate. We impart training about competition issues, and it creates awareness among stakeholders. And the focus of advocacy is with state, central governments, regulators, statutory authorities, colleges, etc. Then we have advisory functions. Central government or state government may, in formulating a policy on competition, they can come to the commission seeking advice whether a particular law or a particular policy is going to increase competition or they can reduce competition in the market. This is section 49(1). However, the opinion of the CCI is not binding upon the government, and section 21 says that commission shall give its opinion on a reference made by statutory authorities. Because section 49 is about the central government and state government, and section 21 is about the other statutory authorities. This is the hierarchy of the appellate process. The orders of the commission are appealable to the National Company Law Appellate Tribunal and thereafter to Supreme Court. The appeals do not lie with high courts. The high court jurisdiction, as far as the appeals are concerned, it is taken out from the Competition Act. However, the high court and Supreme Court, they have jurisdiction under their Article 226 and Article 32. So there are writ petitions that is filed with high courts with respect to the procedural aspect as well as sometimes on merit also, which we find that these days this is a creating problem because the multiple cases are filed across high courts and they delay the process. Recently in Amazon Flipkart case, there were, I think, 25 writ petitions were filed in 6 or 7 high courts across the country. So we reached out to Supreme Court, and now all these writ petitions have been transferred to Karnataka High Court, and the single High Court will now dispose of all these writ petitions. We have extraterritorial jurisdiction also. Section 32, it says that Commission can look into acts which are taking place outside India, but which has an effect on competition in India. Google, Google is an entity. All the products of Google, they are owned and operated by Google LLC, which is a US-based company. Google India or the other entities of Google, they are just sellers on the Google LLC. They do not own the platform. But Section 32 gives us power to examine conduct of any entity which may be located outside India, which has business operations outside India, but if its conduct is having impact in Indian market, we can examine that particular conduct. So Section 32 allows us to exercise this jurisdiction. For discharging its duties and functions, Commission can enter into memorandum or MOUs with foreign countries, and Commission has signed MOUs with EU, US, Australia, Russia, BRICS, multiple other entities, authorities globally. So this Competition Amendment Act 2023, it was introduced in the Parliament in August 2022 after the recommendation of the Competition Law Review Committee, which submitted its report in 2019. The committee submitted its report in December 2022, and the bill was passed by Lok Sabha on 29th of March 23 and by Rajya Sabha on 3rd of April, and the presidential assent was accorded on 11th of April 23. And the bill, the Amendment Act has now been notified in a staggered manner, where on different dates the different provisions were notified. Some of the changes that were incorporated I have already explained. So apart from them, there is a limitation period of 3 years now which has been introduced, that once a cause of action arises, a complaint can only be filed with the Commission within a period of 3 years. Commission has been given power to relax this particular condition in appropriate cases if there are sufficient causes for not reaching out to Commission within this particular time limit, or if the cause of action continues to arise, the conduct is still ongoing. Then penalty has been indexed to global turnover as compared to the relevant turnover. The Supreme Court in Axel crop case judgment, they said that Commission can impose penalty only on the basis of relevant turnover, which in a way taken out the deterrent effect of penalties. So we reached out to government, and government agreed that penalty in line with the global best practices, penalty has now been indexed to global turnover, but this is the maximum cap that we can go. Commission generally starts with relevant turnover only, but it can go up to 10% of the global turnover. Then hub and spoke I've already explained. Then the time limit for review of amendments combinations has been reduced from 210 days to 150 days. Deal value threshold has been introduced. The Amendment Act also required to issue guidelines. So we have issued penalty guidelines after this particular amendment, where we have prescribed a process how we will calculate penalties under different sections of the Competition Act, and what would be our methodology for calculating penalty, what would be our aggravating factor, mitigating factors, deterrence, how to create deterrence. So all this methodology has been prescribed under the penalty guidelines that the Commission has issued in 2024. The Amendment Act also introduced these two important mechanisms, settlement and commitment mechanisms, where the Commission can reach out with a settlement with the parties or an agreement with the parties, so that early distortion can be avoided in the market, and market can be corrected on in a quicker timeline. Because we were seeing that a case took around 6 to 7 years before it can reach a finality, because there are so many appeals. The process with the Commission itself is very detailed. So under Section 48, Section 48A deals with settlement, and Section 48B deals with the commitment. The difference is that commitment is applicable after passing of a prima facie order of the Commission. And the application has to be made within 45 days of the receipt of that particular order. Then settlement is after the DG completes its investigation report, and they submit an investigation report to the Commission, and Commission forward the same to the parties. So settlement happens once the investigation is over, and commitment happens when the Commission has directed the DG to start an investigation. The other difference is that under settlement, because the Commission has already conducted the investigation, there is a provision in the amount, the penalty that could have been levied on them in case of contravention is found. So under settlement, there is a monetary outgo on the part of parties, but this is not applicable in case of commitments. So it makes the commitment process more incentivized, and the parties are incentivized to come to the Commission at the commitment stage, because there is no monetary outgo, and Commission also saves its resources in investigating the matter. There is no requirement of giving a contravention finding that the parties concerned have contravened either Section 3(4) or Section 4 of the Act. There is no requirement of giving a contravention finding. Settlement and commitment orders are not appealable. Then there are time limits in the regulations which prescribes how much time the Commission can take in these proceedings. Commission may agree to settlement or commitment proposal after taking into consideration the nature, gravity, and impact of such contravention. So if a particular conduct has a market-wide, it's a large impact on the market, Commission may decide that this case is not fit for settlement or commitment. So Commission considers all these aspects while deciding a commitment proposal or while formulating a commitment or settlement proposal. The manner of implementation and monitoring is determined by the regulations. So the regulations allow us to appoint monitoring agencies to oversee whether the parties are in effect implementing the commitment and settlement proposal. We can also do market testing of the proposal, so that we are aware whether the proposed solution by the parties will work in the market or not. Section 48C, it provides for revocation or resumption of inquiry if certain conditions are met. If the parties are not able to fulfill the settlement proposal, Commission can revocate its order and the inquiry will be resumed in that case. Commission can issue interim measures also during pendency of a settlement application, not during commitment proceedings. Amendment Act also introduced a process for regulation making. This particular process ensures transparency. Now we are required to publish draft regulations and invite public comments. And these comments are examined by the Commission. And a general statement is also published which explains the response of the Commission to the public comments received. Commission is also required to periodically review such regulations, and we are currently in the process of examining the determination of cost of production regulations. The cost benchmark are used for assessing predatory pricing, and that particular consultation is on as of now. There are exceptions also that if a particular regulation deals with internal functioning of the Commission, there is no requirement of doing a public consultation process. This is about the competition law. Now the Digital Competition Bill. In 2022, Parliamentary Standing Committee on Finance, they submitted a report on anti-competitive practices by big tech companies. They recommended a digital competition law and which will be applicable only to limited big technology firms, which they refer to as systemically important digital intermediaries, CDs. This particular report discussed 10 major anti-competitive practices. These are anti-sharing provision, bundling, tying, M&As, exclusive tie-ups, restricting third-party applications, platform neutrality, data usage, deep discounting, search and ranking preferencing, advertising policies. So these 10 practices were largely taken from the jurisprudence of the Commission, where the Commission was already looking into certain conduct of the large technology firms, or they were taken from global development. For example, European Commission was considering a lot of practices of Google, Amazon, Flipkart, Google, Amazon, Apple, Meta. So these practices were picked either from the Commission's activities or from the global developments. Following this particular report by the Parliamentary Standing Committee, Ministry of Corporate Affairs constituted a committee called Committee on Digital Competition Law in 2023. It was tasked with following terms of reference to review whether existing provisions of the Competition Act 2002 are sufficient to deal with the challenges of the digital economy, to examine need for an ex-ante regulatory mechanism, study the international best practices on regulation of digital market, to study other regulatory regime of government policies regarding competition in digital market, study the practices of these CDs, which has the potential to harm the digital market. They were also required to submit a draft bill. The committee submitted its report in February 2024, where they recommended an ex-ante framework, separate digital competition bill, and they given a draft of the bill also. The committee explained that there is a complementary relationship between ex-ante and ex-post framework because given the dynamic nature of the digital market, it is not possible to examine each and every conduct every time. So the committee felt it is important that some do's and don'ts can be listed, which can give more clarity and transparency to the technology firms, what kind of conduct is permitted and what is not permitted. And this kind of arrangement will complement the ex-post enforcement, which is covered under the Competition Act. Committee also examined in detail the Competition Act. They found that the functioning of Competition Act is very resource intensive and time consuming. It takes around 4 to 5 years in the commission for a case, and then there is appellate process. So there are multiple cases which are stuck in Supreme Court. We decided NSE predatory pricing case against NSE in 2011. That case is still pending with Supreme Court. So it's been 14 years and the case is not being listed before Supreme Court. We passed a case against DLF in 2011. That case is still pending with Supreme Court. So the appellate process is so large that by the time interventions are effected in the market have changed. These digital markets are so dynamic that we cannot wait for 4 or 5 years, even these 10 years. Once the decision reaches a finality, and then the market will be corrected. So the committee found it better to have an ex ante framework which will support the ex post framework. The committee found benefits of early detection and intervention in the digital markets. There is a concept in digital markets, market tipping. I don't know how much of you know. The market tipping is basically a feature of the digital market where once the market has distorted, it becomes very difficult to change the market structure and make the market more competitive. Google search is dominant for last 10-12 years. And multiple attempts by multiple jurisdictions across the world have failed to break the monopoly of Google. Because Google has reached that particular level of market. The market has tipped completely in favor of Google. Even if the Microsoft and other competitors in the market are invest a huge lot of money in making their search function properly, the users are not willing to switch over to them. They will use Microsoft as an additional search engine, but they will not use Microsoft as a primary search engine. Recent the changes in the ChatGPT, OpenAI, they also tried to change or distort the search engine of Google. Again, they failed. They are not able to challenge search functionality of Google. So the market has tipped completely in favor of Google. So this is the problem with digital markets. The winner takes all. Once a winner comes into the market, they will just destroy the market. They will take over the market and no one will be able to enter. So therefore, timely interventions in the market is very important in these kind of dynamic markets. The committee also noted that the ex post remedies are very narrow in scope. For example, if we see a particular conduct against Google and we found there is a problem, we ask them to change the policy. Same conduct by Apple, we have to examine again, we have to investigate again, we have to do the entire process again and ask Apple to change the same. Then there could be a third company. So this is a case-specific intervention. This is the limitation of competition law. So instead of doing this case-specific problem, addressing the problem, the ex-ante framework is better, which explain what to the technology firm that this is not acceptable, this is acceptable, this is how you will change your business model. So this is another problem with the competition law. And therefore, the committee recommended a de novo Digital Competition Act that will enable CCI to selectively regulate only those enterprises or those companies which have ability to influence digital markets. So not all technology firms are required or will be covered by the Digital Competition Bill, but only a certain group of entities will be covered by the Digital Competition Bill. Coming to the broad framework of a Digital Competition Bill, the Digital Competition Bill is applicable only in respect of these 9 services. The other services or the other digital services are not covered by the Digital Competition Bill. These are online search engines, online social networking services, video sharing platform services like YouTube, web browsers, Chrome, Bing, then online intermediation services. We will cover Amazon, Flipkart, Swiggy, Zomato here because they are doing online intermediation between buyers and sellers on the platform. Operating system, Google, Android, Microsoft Windows, interpersonal communication services like WhatsApp, online advertising services like the one that Meta and Google operates, then cloud services, then Microsoft, Google, and Amazon. These are 3 players in these cloud services. So only these services are currently part of the bill. The obligations under the draft Digital Competition Bill is applicable only to select digital platforms which are referred to as systemically significant digital enterprises, SSDEs, and the definition says SSDE is an entity which is holding significant position in the provision of a specific CDS. CDS is core digital service. So if a particular entity holds significant position in the provision of a specific CDS, that can be categorized as an SSDE, and it will be required to follow the obligations under the DCB. How the SSDE will be decided? There are certain quantitative thresholds which are in terms of turnover, both Indian as well as global, gross merchandise value, then global market capitalization. So these are all OR. So one of these three is met, then one part of the threshold is met, and the other part of the threshold is the number of end users. It could be end users or it could be business users. So one of the three and then second part. If this is met, then the quantitative thresholds are met, and that entity can be categorized as SSDE. The Digital Competition Bill also has qualitative determination. For example, if an entity do not meet these threshold, but its business operations are such that it is required to be covered under the statutory framework, then on the basis of certain qualitative factors, Commission can designate such an entity despite not meeting quantitative threshold as an SSDE. Then there are self-assessment and reporting requirements, where the entities concerned, they will self-assess whether they are meeting these thresholds, and if they are meeting these thresholds, they have to report to the Commission, we are meeting so and so thresholds. Then the Commission will examine, and the Commission will designate them, and their obligations will be specified. Draft competition bill, digital competition bill is only a principle-based legislation. It's not a rule-based legislation. It only gives principles, and the service-wise code will be specified by regulation. For example, how these principles will be implemented by a search engine. So there will be a separate regulation for search engines. That regulation will specify the rules for search engine, and those rules will be based on these principles. First is the fair and transparent dealing. SSDE shall operate in a fair, non-discriminatory and transparent manner. Then SSDE shall not favor its or related parties' products. Data usage requirements are also there. Then restricting third-party applications, anti-steering, tying and bundling. So all these are principles, and the principles which are applicable in respect to a particular CDS, regulations will specify the rules for that particular CDS. And there are exemptions based on objective justification, for example, security of the device, security of the OS. So these kind of objective justifications are also built into the bill. Other provisions of the Digital Competition Bill are compliance and enforcement provisions, which are largely similar to Competition Act 2002, information gathering and investigating powers, interim measures, sanctions which cover both monetary and behavioral, cooperation with other regulators, non-obstante clause, that is the bill is in addition to and not in derogation of other statutes. There are implementation mechanisms and implementing regulations and guidance notes. So this is a broad framework of the Digital Competition Bill. Thank you.
Thank you, sir, for such an insightful and concise lecture. The floor is now open for Q&As. Are there any questions?
Good afternoon, sir. First of all, thank you for this insightful session. My question to you is that, as you said that CCI has now started working in the digital market, but there are new problems also arising. Can we as consumers come together with the CCI to deter predatory pricing and unfair trade practice by the companies, especially that in the digital sphere? For example, companies like Swiggy and Zomato, as you just said, they have made a duopoly, and they have been charging some really unnecessarily frivolous fees like platform fees, GST on platform fees. Then again, some companies have also started charging offer handling fees, which makes no sense. So can something be done about this? Why are these not being regulated?
Anyone can approach to the commission. So there is no requirement of that. Earlier there was a view that only an affected party can reach out to the commission. But Supreme Court in Sameer Agarwal has clarified that there is no requirement of a locus standi for a person to reach out to the commission with a problem. So anyone can come to the commission and file a complaint. So this is the answer to problem number one. The second issue is charging of different kind of fees by Swiggy and Zomato. Commission can examine the conduct only in the framework of section 3(4) or section 4. There is an ongoing case against Swiggy and Zomato under section 3(4) vertical agreement where the commission is examining into the multiple policies of these platforms vis-a-vis the kitchen platforms, their own kitchen, in-house kitchen, which are listed on the platform, and the competitive advantage that these platforms get by the data, which is not available to the other restaurant partners on the platform. But as far as this charging of fees is concerned, if it can be established that this kind of fees is not it is not something which is allowed under section 3(4), then only the commission can see. But as a platform, if they are charging a platform handling fee, because they are at the end of the day they are providing a platform. If they are charging a fee, I do not think that how charging a fee as a handling fee is a problem under competition law, and why the platform should not be allowed to charge a fee.
Sir, then another example, for example, during sales on Flipkarts, we can usually see that they give us offer from different bank credit discounts. When we avail those discounts, they again charge something like offer handling fee.
I think these are something as a platform they are allowed to do. I don't think that this is something which can be examined under competition law. The pricing related practices which are only covered by the competition law are the unfair and discriminatory pricing. If it is that they are charging fees with a particular customer and not to the other customers, so this can be a discriminatory pricing, and that can be examined. But if they are charging a fee with all the customers, then I do not see any problem. Or if the fee is unfair in itself, if it can be established that the fee is unfair, then it can be examined.
Thank you, sir.
Good afternoon, sir. We are very much glad to have you here. Sir, I have two questions. My first question is, does CCI come under RTI Act 2005? And the second question is, are there any exemptions under RTI Act?
CCI is covered under RTI Act, so I'm not aware of any exemptions under RTI Act. So I didn't agree get that question. You are asking for exemptions under the RTI statute or under the competition statute?
Under the RTI Act. Because
Sorry.
there is investigation team. So is there any exemptions that the commission cannot give such informations?
Okay. The matters which are under investigation, Commission do not disclose the details of those investigations till the time matter is being considered. Once the matter is over, because these submissions that are before the Commission, generally they have lot of business secrets. Because when we reach out to these platforms or these companies, they give a lot of business secrets and commercially sensitive information to us. That kind of information is the RTI Act allows us not to disclose that kind of information to the applicants. So if the matter is under investigation, we generally do not disclose the information that we have received.
Okay, sir. Thank you, sir.
Good afternoon, sir. Sir, anti-competition agreement. As an anti-competition agreement, and I mean, how it works, making fixing a price, and how it is, what is the agreement, and I don't know. And I think the agreement, sir, actually competition agreement, practical in our practical life, how it is work at competition agreement.
Your question is not audible. Price fixing I got. I'll give you an example what is price fixing.
Hello?
Yeah.
Sir, I want to say how it is fixing the price.
See, price fixing, why we consider price fixing and how it operates is the competitors or suppliers in a market are supposed to operate independently without talking to each other as far as pricing and other decisions are concerned, which are commercially sensitive. Currently, I'll give you a very plain example of Coca-Cola and Pepsi. Suppose right now they are deciding their prices on their own cost structure. But what if they come together and decide, let's increase price by 5% by tomorrow? So this kind of price fixing arrangement between competitors, this is called anti-competitive under the section 3.3. So these kind of arrangements where competitors come together and decide they fix prices to be charged for their services, these kind of arrangements are considered to be prohibited under section 3.3.
Thank you.
Good afternoon, sir. So what measures will CCI take to address the concerns related to protection of data privacy in the sphere of emerging sectors like digital marketing, AI, and etc.?
See, data protection is one field. The commission is looking how it will affect its own functioning.
Yes, sir, sure.
The data protection law is yet to be notified by the government. Once the DPDP Act is notified along with rules, there will be a broad framework of how the personal data is being governed or collected by the companies, be it digital or otherwise. As far as our role is concerned, we examined the interface between competition law and data protection law in our meta order, because one of the contention of Meta and WhatsApp before us was that all the issues that we are examining in that particular matter, the how the privacy policy was changed and how the users were mandated to share their data with the Meta for advertisement and other purposes, apart from providing WhatsApp services. All these issues will be governed by the data protection law. The data protection issues in the same matter were raised before Supreme Court and Delhi High Court in Karmanya cases, and there are two other cases where it was alleged that the 2021 policy update of Meta and WhatsApp, it violates section 14 of the Constitution. So the commission examined these kind of arguments from Meta and WhatsApp and noted that the jurisdiction of CCI is only in respect of Competition Act. Data in case of digital platforms, they create a very important role to assess or to decide the competitive level of a particular platform. Google, why it is Google today? Because they have lot of data about us. They collect data, they process that data to provide better services to the users. And that's why people love Google. They go back and to Google for the services. Amazon collects a lot of data and they use that data to improve their platform. So all these digital platforms, they collect data which decides the competitive stage or the competitive edge of these platforms. So this, as far as data usage for deciding this competitive edge is concerned, Commission has a role to play. But when it comes to decide the privacy of a particular individual, I think this is something which the data protection law, when it will be notified, it will take care. As of now, we are not looking into the privacy of individuals as required by the data protection law. In Meta case also, we only looked into how the privacy policy was implemented, whether you have given a choice to the user or not. This was the issue number one, that when you implemented the 2021 policy update, you did not give a choice to the users to opt out of data sharing. And the way it was implemented, it was take it or leave it kind of thing. We found it unfair imposition. And second aspect was the exclusion from the market, the exclusion of rivals of Meta from the display advertisement market. So these were the aspects that the commission examined as far as the data is concerned in the Meta case, and the privacy aspect of data will be looked into by the data protection body whenever it is notified.
Thank you, sir.
Good afternoon, sir. I have a question. Sir, how does competition commission is working in the formal sector? That's great. So I have an example. Like I have a problem actually. I have seen that competition commission is involving in the real estate like DLF, but there are certain problems of price increase and non-following of the antitrust laws in the informal sector, especially in the tier 2 or tier and parts of the tier 1 cities in the real estate market. So how is competition commission is working into this?
See, if we receive any case of abuse or violation of the law, then we can examine these cases. Till recently, we were receiving cases in the real estate sector alleging contraventions of Section 4 of the Act. But in those cases, we found that the entity concerned is not a dominant player. We can only intervene in case of dominant players. We passed a judgment against DLF because DLF was found to be a dominant player in the Gurgaon market. So it all depends how the market is defined, whether the entity concerned is found to be dominant. If that entity is found to be dominant, then the commission jurisdiction is there and commission can pass orders. But unless and until an entity is dominant in that particular market, commission do not have jurisdiction to intervene in those markets, and it lies entirely with the sectoral regulators to look into that issue.
So, but in small towns, sir, there are certain informal and private players who are into doing the same. They are being dominant and they are harassing the other.
So, if such kind of information comes before the commission, and if commission feels that they are dominant in that particular area, geography, then commission can surely look into that. But as of now, we have not received such kind of complaints.
Okay, sir.
We'll take one more question. Yes.
Sir, good afternoon. Sir, when it's come to sector specific, especially in dry land, that is agri sector. So I wanted to ask a few questions like what the new thing that CCI is working in relation to dry land, with like especially with special reference to agri sector.
I don't think we have received any case. The development of a particular sector and how that particular sector will evolve, the responsibility of the same lies with the sectoral regulator. Our role is limited to the extent that there should not be any anti-competitive practices being followed in that particular sector. So, for example, if we talk about TRAI and the commission, TRAI will decide how the sector will evolve, how the telecom sector will evolve, what are the policies that has to be followed by the telecom players, the broadband suppliers and all that, what kind of speed should be given, how the consumer complaints will be solved by these companies. The TRAI will do all those things. The role of commission is limited to the extent that the telecom players should not collude with each other in terms of Section 3.3. The telecom players should not engage into a vertical agreement with their downstream or upstream suppliers, which affects competition in the market. Or if there is a dominant telecom player, they should not abuse its dominant position. Commission's role is limited to Section 3 and 4 only. The responsibility to evolve a sector lies with the, or to regulate a sector lies with the sectoral regulator.
Sir, actually, few months back when I had attended one conference that was specific to like CCI has conducted, they have sponsored in IIT KGP, where that was special referred to blue economy. But when it's come to green economy, that's what I wanted to ask, that CCI is doing a lot when it's come to blue economy, that wetland. But when it's come to dry land, since it is very important for us when it's come to the economic aspect. So that's what I wanted to ask, that is there any few like cases that is CCI is receiving in relation to dry land?
See, environmentally friendly policies issue, globally there is a debate that what role competition law can play in promoting environment-friendly policies. What is happening globally is that when these agencies look into a particular conduct of parties, they examine whether the particular conduct is likely to result into environment-friendly policies or not. And if that is happening, then they consider that particular impact on the environment while deciding whether the parties concerned have violated their statutes or not. For example, if there is a cartel between two suppliers, but the cartel is in respect of promoting a particular green technology, so they may allow that particular cartel and they may not penalize those companies. This is the role competition agencies can play in promoting green technology or the environment-friendly technologies. In India, I do not think that till date we have received any case where we have examined such kind of issues in our analysis. These are theoretical as of now in India. Globally, there are few cases, but as and when we receive a case where we receive such kind of issues before us, I think Commission will take a call whether we are an apt body to consider, because deciding whether a technology will result into a better environment or not, whether competition authority is a fit body to do that analysis or not, this is also a question. Or whether we should engage with some sectoral regulator or experts which have knowledge of whether a particular technology is green or blue. So I think this all depends on how the cases will come to the Commission. As of now, it's all theoretical. We do not have any cases, but yes, we are open for that. As and when we receive such cases, then we'll take a call how to deal with such issues, because these are important issues.
Okay, sir. Thank you, sir. That's what.
Thank you, sir, for beautifully handling all the questions. We shall close the floor for Q&A.
Thank you.
Yes, and I request our Dean ma'am, our HOD ma'am, Dr. Bonita Bose, to kindly deliver the vote of thanks.
Good afternoon, everyone. It is an absolute honor to deliver the vote of thanks for today's insightful lecture on the overview of competition law by Mr. Sachin Goel. On behalf of the Department of Law at Sister Nivedita University, I extend my heartfelt gratitude to Mr. Goel for taking the time to share his expertise with us. Your session not only deepened our understanding of competition law, but also highlighted its real-world significance in ensuring fair market practices and consumer protection. The clarity with which you explained complex legal principles and their implications has been truly enlightening. At the very onset, I would like to extend my heartfelt gratitude to the Honorable Vice Chancellor, Sister Nivedita University, Professor Dr. Dhrubajyoti Chattopadhyay, for his constant support and leadership in fostering academic discourse. I am immensely thankful to respected Registrar Professor Shumon Chatterjee sir and Chief Finance Officer Shubir Rokit sir, who helped us in making necessary arrangement to make this event happen. I would also like to express my sincere thanks to the Dean of the School of Law, Sister Nivedita University, Professor Dr. Debashri Mukherjee ma'am, and Professor Dr. Manik Chakraborty sir, Professor Emeritus, School of Law, Sister Nivedita University, for their constant guidance and support. Also, I am immensely thankful to the esteemed faculty members of the school who made this event possible. A big thanks to the organizing team of the volunteers, administrative staff, the Department of Mass Communication and IT, the administrative staff of the university, and other all non-teaching staff for their hard work and dedication in ensuring the seamless execution of this lecture. A special appreciation to the students and attendees for their enthusiastic participation, which made this session even more engaging. Once again, thank you, Mr. Goel, for such a valuable and thought-provoking lecture. We hope to have the privilege of learning from you again in future. Thank you all. I would like to request the students and the faculty members to please come up for a group photo. Sir, please. And we should take the photo while this is visible. So please come here. Students, come here.